Unified Family Court System is a system that the Supreme Court of Florida started talking about in 1988. And so over the last 30 years, it's evolved eventually into the system that we have right now, even though that system is used more intensely in some circuits than it is in every circuit. So it is a blend of the dependency court system and the family court system, with the concept that when you have a judicial process going on for a child or children, one judge needs to hear all this, or sometimes in some circuits a panel of judges need to hear all this, so that all the available information will be there for the court to make the most informed decision in the best interest of the child. So that's the concept. All right. In the beginning. All right, just before we get into this, the source material of all of this has come from the Florida Supreme Court. Well, most of this has come from the Florida Supreme Court. They have a lovely website. Don't worry about naming the title. If you type into your browser, Florida Dependency Court Handbook, it will take you straight there. And it has a family law handbook, and it has a dependency court handbook, and in the mix of all those things is a toolbox to talk about how all this stuff works. So you're about to see that. If you've never looked at it before, and I've talked to lawyers, some of them say they see it and use it all the time, and some of them say, I've never seen it and I don't care. So we're all over the board. This is today going to give you information about what's there and a suggestion of how you could use it in your circuit to achieve better results. A suggestion, because we don't tell anybody anything. Okay, it begins with the concept of Florida reviewing what's going on in this country. I am not going to read these slides to you. I hate it when people do that. I mean, if I look out here in a minute and I see almost everybody on their phone, I'm going to do something drastic, just so you know. So reading slides is something I don't do, and I don't think anybody should ever do that ever. But this is the concept here. As you read through this, you'll see what's on this Florida Supreme Court website that motivated the Supreme Court into developing a system that would bring unity into a family so that, again, their trusted foot soldier, which would be a circuit court judge, can make the best decision for the family and the children. The legislature got involved. They pushed it on through. They came up with model family court processes, toolbox, handbooks. They handed those out. And again, some circuits embrace these and other circuits not so much. It depends on where you were and, frankly, who the administrative judge was in an individual circuit. Our administrative judge took his time. He wasn't sure about it. Other judges jumped right on it. Anybody in here have a panel of unified family court judges for their circuit? Nobody's here from Pinellas County? Those guys, okay. How they've done it, in larger counties, they split it up geographically. A judge will be assigned to a geographic section of a county, and every case that comes in from that area goes to that judge. In other circuits, like Pasco, you have one judge who does everything anyway. Same thing in DeSoto. If I'm in DeSoto Juvenile Court talking to the DeSoto Juvenile Court judge, I'm also talking to the DeSoto Family Court judge, because it's just him. So that, in a way, perfectly fits the model the Supreme Court had in mind. He hears everything because there's nobody else to hear it. Kind of works out. All right. Again, this is more of the history of how they came in. Supreme Court's very good about this. If you've ever had the great pleasure and honor to read a Supreme Court opinion, after you've read the first 20, 30 pages, you realize you now know the history of whatever hell the issue was that caused them to write the opinion. Then they finally start talking about the facts, and then they go into the analysis, and finally they say who wins and loses. So when they write anything, that's the same formula. Let's talk about the history of how we got here before we tell you anything you can actually use. On and on and on it goes. All this is on the website. Just so you know, there'll be a test before you leave this room, and if you don't pass what you're looking at right now, you can't leave. Nobody expects you to know this stuff. But they did come up with some really good ideas that they can use in family court, in juvenile court, in every court. This is the one, the number one. It's, of course, the same number one that's in everybody's courtroom. Despite who you work for or with or against, no one in any court walks into there thinking, I'm going to take these kids down. They're never going to do well after I'm finished saying what I'm going to say. Unless, of course, they're a witness, then kind of. Depends on what they have to say. But everybody wants the children to be safe. What we fight about, like cats and dogs, is how does that work? Is the state right? State, I'm going to say, is DCF, is the guardian ad litem right? And they're not on the same page all the time. Are the parents right? And I've done this for a long time. I can tell you at some point in time, all of them are right and all of them are wrong. And there we go. There's plenty of case law out there. The best interest of the child are paramount. So what we should all be working for and with is what is the truth about what's really in their best interest. This is just fundamental, and this is not always true. I'm going to give you an example, no case names and no people mentioned. Early childhood court. Anybody here know what that is? Some of you, okay. Early childhood court, specialized court, and by voluntary acclamation in some areas, very young children under 5 are brought into a specialized court, and it's supposed to be the epitome of therapeutic jurisprudence, meaning everybody's supposed to work together and move forward. Yes, bad stuff happened in the past. We're working on it, and we're going to move forward toward a positive outcome. That's the overriding principle of early childhood court. And yet, some lawyers treat it like it's a regular litigation. And they will come in and blame and point fingers and say this person didn't do this or they didn't do it right and the child's been badly affected, blah, blah, blah. Now, these are not normally, hopefully, the therapists and parenting instructors who are working with the family. I've never heard those guys go off on anybody. But the lawyers, we're trained as litigators. We know how to fight. We have issues being nice. It's just not in the DNA they teach you at law school, at least not when I went there. So you have to kind of let it go. You have to let the zen of the moment take over and go with these therapeutic folks, even though you're saying, I don't like what they just said. All right. Number 4 is kind of the idea of the unified family court. Blend it all together. If you've got issues in one court, the kids are doing fine, the mom's doing fine, the dad's drinking a little bit too much, gets a little angry when he's had a little too much, and it's a divorce case, something happens, it ends up in a family law case. Sometimes we've had family law cases brought into dependency court because one parent has lost it and the other parent has failed to protect, meaning, in some investigator's mind, they didn't leave the one who's the bad guy. So again, what they're looking for here is a way to make it all happen, pull it all together, and the unified family court is the concept. Okay, and you can see as you go further and further into this, it begins to get a little therapeutic key. We want everybody to do all right, we want everything to be okay, and everybody's needs ought to be met, and the court's responsible to make sure all this happens. All of this stuff is written down from a judge's perspective. Okay, judge, you're on our webpage reading our bench book about how you're supposed to run your court. So if you're the lawyer and you've got to present, if you know what the judge is supposed to be doing, what their marching orders are, you can tailor your presentation to meet that need. I can tell you, no two juvenile courts are alike. I've never seen two judges alike on any particular bench. And if you're the lawyer, you play for your audience, and you have an audience of one. So you give them what they need so that you can get what you need. Hopefully, it's what your client needs as well. Okay. People are going to fight about how to do this, which is why we get away from the therapeutic process. But again, we can agree to disagree without getting blameworthy of the various parties and things that go on in both courts. Community resources, if you're in dependency court, you know that's service providers and community-based care guys. So again, this is tailor-made for Dependency Court personnel. They're there all the time, parties to the case or not. Now, the long-term stability is what we really want to talk to you about today. You can spend a year, year and a half, 2 years crafting out a solution for a family, knowing that juvenile court, which is supposed to be the emergency room of family law courts, you go there when you have to. They treat you and let you go on to family court, or fix everything and just go home, or never go home. But that's what it is in the beginning. It's the triage of family courts. Long-term stability. If you can come up with a solution and a long-term contact plan, mom's going to do the caregiving role, dad's going to have this form of contact, blah, 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 and we're going to move forward, it ends at juvenile court. When that lets go of jurisdiction, it is not enforceable by anybody else, unless you take our suggestion, in which case it will be. Okay, in juvenile court, we don't have any economic considerations because everybody's broke, right? And if they have money, they hire Debbie. And then we have highly trained and motivated judicial and non-judicial personnel. Has anybody else noticed that about every 3 months, the community-based care personnel just graduated college? I mean, you look out over them and you wonder who these people are, and they all look like they're like 12. Anybody else notice that, or is that just the really old people? Because I can tell you that's what it looks like to me. Okay. Oop. As you go to this website and start looking through this book, they're very conscientious of what questions the judges who are looking this stuff up may have. So they have a whole section here on questions and answers to those questions. Like one of the big ones, do you consolidate? No, you don't consolidate. You coordinate, you have it transferred in. The powers of a circuit judge to hear a family law case cuts both ways. Dependency court judges can hear family law cases. It is not a one-way street. There was a case in Bay County I know about, without giving any names. After 2 years, DCF had not found a solution. There were 3 kids involved, and they couldn't decide where they should go. They've been placed with the grandparents for 2 years. There was a lot of argument about have the parents done their case plan or not? Had they reached effective behavioral modifications or not? They didn't agree. So what the parents did was they signed their kids' rights over to the grandparents, the same grandparents that had them, and they did a temporary custody to a relative action in family court. DCF marched in and said, you don't have jurisdiction to hear this. To which the circuit court judge said, I have jurisdiction, I'm a circuit court judge, and gave temporary custody to these same grandparents and shut down the dependency court case. So I knew about this because I knew one of the litigants closely, and I waited for the appeal, which never came. And I think it never came because somebody did not want a precedent out there that let the rest of the state know that this was possible. But if you go to the Supreme Court website and start looking at these things and start talking about what authority a circuit court judge has, it's kind of omnibus to hear these cases. It doesn't matter if it's in juvenile court or family court, they can hear it. Now, they don't want to hear a juvenile court case. No one in their right mind would want to hear a juvenile court case. There's too much stuff going on. There's too many people pointing the fingers at each other going, I'm right and they're wrong, and this is going to be a disaster if you listen to them. And of course, everybody wants in the best interest of the child, so you got this crowd of people yelling at each other, and you got a judge going, what are they supposed to do? Well, they've got to cut through the arguments and get to the truth. They've got to decide what that truth is, and then they know what to do. As a footnote to that, to any judge who may hear this, It is not in the best interest of anyone for a judge to take a particular side on a regular basis. To believe that the guardian's always right, or the parents are always right, that's never true. Or the department's always right, that's usually true. And take their side. Just don't do it. Because then the truth is out there, but you'll never see it. You got to do the judge thing. Okay. Sure. And now Debbie's going to talk.
I'll stand over here.
This was not rehearsed.
When I file a family law case and we already have a dependency case, what I will do is ask the clerk of the court, we file a notice of related cases in the family law case that notifies the clerk of the court to send it into the juvenile dependency division. Sometimes if that doesn't happen, it usually just takes a phone call to the clerk pointing it out to them that that needs to be reassigned to the juvenile judge. The other issue is that sometimes they wind up assigning them to a family court judge, and generally just an email or a letter to the judge stating that there's the open dependency case and it should be referred into the dependency court judge. That's what happens, and the judge is very quick to enter an order and send that case in there because Lord knows a family court judge doesn't want to be in that mess. So at any rate, that's an easy way to get it transferred in there, and I look at it as the two cases running kind of parallel, and then when we get to the conclusion of the dependency case, hopefully we're concluding the family court case at the same time. Doesn't always work that way. I've had a lot of real interesting high-profile cases recently where there's been adoption issues and whatnot, but there is a benefit in having one judge hear everything. However, if your judge in the dependency court is on overload, like so many of them are, and they can't hear it all and start calling in multiple other judges to cover these hearings, it's a disaster.
Domestic violence cases have a special considerations to them because sometimes the address of the victim is confidential and they want it to stay confidential. Now that kind of flies in the face of where are my kids, especially if they're living with the victim. Sometimes they're in a shelter, which will never admit that they're there or not. They just, if you need to have a client there, what we do is we call, we leave a message, and we get a phone call back or we don't. It's a little difficult talking to them, but usually the case manager has an idea where they are. Okay. What if a judge doesn't want to do it? That happens if a judge doesn't want to do it, and the Supreme Court has said, figure it out. Basically, you can't make a circuit judge take a case, even though it might be better for the community, for the family, for the child, for everybody involved, but they can't be made to do it. I've not had that problem personally. Has anybody had that problem? We're in their jurisdiction. Usually judges are really good about it, and I told you the Bay County case where the salmon swam upstream and they all dealt with it. Okay. Like I said, in some jurisdiction there's a panel, in some counties there's a judge, and they hear everything circuit. No benefits one way or the other. Now the burden of proof really kind of rises up more in dependency court than it does in family court. Dependency court has a flexible burden of proof scenario, from probable cause to substantial to clear and convincing, substantial competent evidence, and in family law it's basically just prove it, substantial and competent evidence. So I believe that if it got down to, it would be the particular issue. If you're arguing a family law issue in a termination trial, the judge is going to have to go back and forth between clear and convincing evidence for the termination purposes and competent evidence for the family law purposes, but they can do that. They're judges. They can do that. Again, if anybody tells you that a circuit judge does or does not have jurisdiction, refer to this. They do. If you don't remember anything else, they do. If they're a competent circuit judge who has jurisdiction over a particular area in their circuit, then they can hear all of these things. Go ahead.
Can we just ask, how many people in here work for the department and represent the department as lawyers? Okay, so no one, okay, just one, right? No, you do. Anybody else? Okay. Well, I did have a very heated adoption case that I filed, and it was running parallel with a dependency case that was post-TPR and hanging out for a while. And that was what the department argued. They filed a motion to dismiss and delayed the adoption case from going forward. And one of their arguments was that the judge had no jurisdiction to hear that case. And I can tell you that the judge, there were other arguments also, rendered a 13-page order saying they absolutely had jurisdiction to hear that case.
So, for those who are facing that argument, you now know the answer. You're welcome. And at the bottom, again, this is written by judges for judges, so they need to announce what burden of proof they'll be looking at for the record, because anything can end up on appeal. Anything. And the appellate court is going to be looking at these same things. Now, guardian ad litem specifically, simple enough. If you're the guardian ad litem in a dependency case, can you act as a guardian ad litem in a family law case? Well, in a word, yes. If you're the guardian ad litem, you can go back and forth freely. You're good. Did you want to do this one? Okay.
Yeah.
Okay.
Sure. There is a new family court rule out that says that if the judge has to make a decision regarding an emergency and has to look at other cases and entering an ex parte order, that they have to then enter an order providing notice that they did that and set a hearing on it so the other party has a chance to come back in and refute what they looked at. But the judge has the right to look at the related cases, and they often do in our courtroom. We all know that. The judge will say, well, we think the parent has a no contact order in a related case, and they'll immediately look those up. I think the bigger problem comes in for us when we have to take an order that was maybe finalized in the dependency case, jurisdiction's terminated, and we are then trying to file that order in the family law case because that's a confidential Chapter 39 order, and that becomes a bigger issue. So that has to be addressed under seal, or we're going to come up with some other ideas that we're going to give you later in the presentation. The problem is when you file the Chapter 39 order under confidentiality and under seal so that no one else can look at it, it really doesn't help the public that much. If anybody's trying to look up who has custody of this child or how did this end, the order that's sealed is not visible to anybody else.
To be short with that, a judge can see any record they want, and they have full access to all the records in the circuit. When I am fighting about records in a trial, it's where did they come from, and if they're not from our circuit, have they been adequately authenticated, or it's a certified record from the clerk of where they're from. If they are, chances are they come in. If they're not, then I win my objection, and then we go from what's left. But that's more of a trial thing. There we go. And that's really more of the same there. They keep asking what a judge can see as far as records go. The answer is whatever. Communication between judges. Okay, we'll get down to personalities a little bit here when it comes to judges. I'll tell you a real story. Years ago, in one of the dependency courts in southwest Florida, a judge wanted to stop the infighting between the department, the guardian, and the parents' lawyers about how to do a certain thing or what the judge should and should not be doing. And he didn't want to make the decision on his own, so he called everybody together for lunch. So we'd brown bag lunch this thing and talk about his agenda. And he would have issues that he felt like were causing problems, and we would talk about why we thought it ought to go another way. And then he, at the end of everybody's input, would say, all right, this is what I'm going to do, blah, 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 blah. He would go back upstairs, dictate the answer to his judicial assistant, and have it emailed to everybody. He also had it printed out and put on books that he put on 3 tables in the courtroom: DCF table, parents table, and the guardian litem table. And then we did this for months. We would meet twice a month, 4 months. Then it pretty much got covered. It went down to once a month. And then finally, enough of it had been covered, we quit meeting. But we all had books, roughly 6 to 8 inches thick, on our tables. And if some lawyer would get up and start going off about what it ought to be, the judge would say, Mr. King, it was him, I think we've covered this. It's in your book. Why don't you take a look at it now? And wouldn't proceed until he flipped through it and looked. That only had to happen once, and then nobody else had that problem. All right. He was on the bench for about 2.5 years, this judge, and we did all this during that time. Then they rotate out, and we get the new judge. And the new judge said, this is my courtroom. I'm going to do it the way I think we ought to do it. And all the books disappeared. That came out better than I thought it would. So that really brings up a larger issue about training judges to be juvenile court judges. Understanding what they do has a long-term effect on families and children in the community, and how the law ought to work, what's the purpose of the law. And frankly, if they read this book, they have a much better idea, but some judges read books and some judges throw them away. A judge, more than one judge, has admitted to me that when court is over, they go back into the back and talk about us, all of us. Mostly the lawyers, but also the volunteers and the case managers, and you name it. If you were out front, you're a topic of conversation in the back. Just like when we go out in the hall and the judge just gave some ruling, can you believe what they did? How could anybody do that? Blah, blah, blah. If I were judge, I would, yada, yada, yada. And we all have those answers. So don't worry about a judge talking to another judge. They do it anyway. Official and non-official. And they don't have to tell us about it, which they don't. They'll tell somebody that they trust, like, we do this, but not any specifics. But I took it as a message like, behave yourself. We're going to talk about you. Across circuit lines, across state lines, the only time I'm aware of that they need to bring us in to talk about it, if there's a UCCJEA hearing, Uniform Child Custody and Jurisdiction Enforcement Act hearing, about which county or which state should be hearing the particular action. There's supposed to be a hearing. The judges are supposed to talk on the phone with the lawyers present so that we have input before they make their decision. Other than that, they can do what they want. And again, most of these cases are decided by an administrative judge in your local circuit. This is how we're going to do the family law concept. You're going to hear this, you're going to hear that. They issue administrative orders to direct all of us on what to expect. But not necessarily. Things can change and go in a different direction if motions are filed. And again, if the parties can't figure out what to do with a particular judge, there's ways to get it in front of a different judge to figure out what to do. All right. This is a matter of keeping all the litigants posted about what's going on. That should be the lawyer's job, to be honest. However, if you're in the Pendency Court, sometimes you know where your client is, and sometimes you don't. I often find out my client's in jail the night before the hearing because they just got arrested that day. I don't know that. I didn't have him brought over because who knew? And the people who did know, who tell me that he's in jail, didn't bother to have him transferred because, hey, that's my job. It's an issue. Uh-oh, did I hit the wrong button? No. There we go. And there we go. Lawyer's responsibility is to clearly explain the scope. See, I'm reading it. I'm not going to do that. We're supposed to tell the clients what we do, what we don't do, and this can be a big issue if it comes down to a family law case and a dependency case, because the state will pay us a little bit of money to do the dependency and zero money to do the family. Isn't that right, JAC people? Yeah, we see you in the back. And that's okay. That's what we signed up for. But people don't understand that. If you get assigned a client who's indigent in dependency court, and they also have 2 or 3 family law matters going on at the same time, which they miraculously do have lawyers on, or have lawyers on, or whatever, they expect you to step in and take it over and do all the child support and the parenting plans and everything else.
But there are times where we have to step in. Like if our client is being reunified and they're subject to a child support order and their money is all being taken out of their paycheck, unfortunately, we have to give the dependency court judge a court order stopping the child support so that that reunification will not fail. And we have to make sure that that also gets to the child support magistrate or whoever's hearing that to call them in, address the arrearage and whatnot, but then we're out of it. So there are times when we have to do those things even though we don't want to and we're not getting paid to do it.
Call that a snippet. If it's a child support matter that's going to screw up reunification, then yeah, it's within the scope of our representation. If it's some of this other weird stuff that they got going on, I don't think so. And there we go. It's just more of the same. Everybody should know what's going on at all time. Okay, now this is something that could come up. If there's a family law matter, let's say it's a parenting issue, a parenting plan issue that's going on, and there's other lawyers involved, and there's a dependency court case. Can the lawyers come to the juvenile court judge and say, look, we all agree that you can hear just this. Don't worry about the alimony or the equitable distribution or whatever else is going on. Just work on the parenting issue. And the judge can say, if everybody agrees, I can do just that. So you don't have the case brought in other than that issue being brought in, and the parties have stipulated that it will be an enforceable order in the family law case as well. That's not our suggestion, but that's out there. Same thing, if you don't need to fight about it, okay, judge, work on the dependency court issue, but once everybody's okay, we want to go back to the same parenting plan that we've already worked out in family court. We all agree that's what's best once we get over this drug addiction thing. Is that okay? Sure. And here we go.
So the next slide is on what happens when the dependency case ends. And we'll have some more information on that too. But the first thing is that we need to make sure that all of the tidying up has been done. If you ran a family court case in there parallel with the dependency case, and the dependency case ends and you have some type of an agreement worked out between the parents and they're getting divorced, or it's a paternity case, more often than not in there it's a paternity case. If there's any further orders that need to be entered, that needs to be addressed. If there is a need that an income deduction order needs to be entered, or it happens to be a divorce case and there needs to be quadros, that, you know what I mean by quadro, a qualified domestic relations order dividing a pension, those issues should be cleaned up before that case goes back to family court unless you've agreed otherwise. And then you need to have an order reassigning the case back to the family court case. And what I did to the family court judge, what I do in mine is if I give a proposed order to the judge after she's heard a paternity case or something, in the very end I put that after 30 days of the entry of this order, the clerk of the court is directed to redirect the case back to the family court division. I've learned that over the years because I've handled so many of these cases in there, and what happens is we may have a paternity action that's all settled and done, and it's been done for a while. Somebody files a supplemental petition to modify, and guess where it's heading? Back to dependency court. There's no dependency case anymore. So then you would have eventually the dependency court judge winding up with some of these family law cases when there's no related dependency case. And that's the last thing these dependency court judge want. So we have to have that in the order. And eventually, you know, the family court cases would all pile up on the dependency court judge. I went to court the other day to finish up a family law matter. It was a temporary relative custody placement order. And before I finished it up, I had it transferred out of the dependency division because the dependency case had been dismissed. And when I went into the family court judge, that was the question he asked me. Why are you here, and why isn't this being heard by the dependency court judge? And I said, that's a very good question, because under the unified family court system, the dependency court would no longer have jurisdiction of this case because there's no dependency case. It's over. And but for that, the dependency court judge would wind up with this backlog of old family law cases that are being reopened. And he accepted that. He had a few other questions, and then he granted the motion. So that's why we need to send that out. We don't want to have an overload in the dependency court because I think we already have a lot of overload. And I'm giving you some sample transfer language here on what you can put in your orders, and you can look this up. We gave this to the Guardian Ad Litem program to upload, and that's just something you can put in there. And then I have an order, the next one, and that's just an order transferring the case back out. So, you know, if you realize your court ended 2 years ago and something's rearing its head again, you forgot to transfer it out, the dependency court judge will be happy to sign this order and send it back to family court. These are yours. Oh, they are. Some of these are the same.
This originally came out as one big slide that had all these different concepts on it. So if you just read over them real quick, it just goes to reassure you and whoever else needs to know the issues overlap. What's best for the kids, and it can include issues like who's going to live in the house, who's going to have contact, when are they going to have contact, who gets to register them for school, who gets to attend classes, or is there restricted visitation. All those issues are the same in both courts. Oops, I'm going to go back on that one just so you can read it. But again, it goes on and on through the book, reassuring every judge or every lawyer who has to read this stuff. You can do it in either courtroom. Whatever your issue is, whatever your concern is, under a unified family court concept, the judge is sitting there as a unified family court judge. They can hear dependency issues, they can hear family court issues, but we tend to keep them apart for reasons that aren't required by the Florida Supreme Court. Okay, well, we're getting now into the crux of the matter. When the jurisdiction of the juvenile court ends, and there's been a decision made about where the children are going to live, what kind of visitation the other parent gets, and jurisdiction of the court is terminated. What's a parent supposed to do if the other parent after that says, I don't like this, I want my kid? They can always call the police and say, I've got this order that says they're supposed to leave with me, and a police officer typically will follow whatever order is there. Sometimes they don't. Sometimes they say, this is a juvenile court order, I need a family court order. Can they go to family court to enforce the juvenile court order? It can be modified in a family court order, but a family court doesn't have jurisdiction to enforce it. That lies strictly with the juvenile court. And if the juvenile court has relinquished jurisdiction, there's no venue for the parent to go. But don't take my word for it. Let's get right down to it. No. How long is this supposed to last? Now, there is a rule that says the department shall, keep a case open for at least 6 months. Not a statute, it's a rule. And then you've got this case. which says something different. This case is still on the books. The whole point of juvenile court, like I said, is ER. You get in, get your emergency treatment taken care of, and you get out. Did you want to do this?
I can barely read it. The King v. Jordan case. The King v. Jordan case is a case that stands for the proposition that when a custodial arrangement was ordered in a dependency proceeding, a determination was made to place the child with a reasonable adult, preferably a parent, a responsible adult, and without the necessity of considering all of the factors. And what they're talking about are the factors in 61.13. When we place a child in dependency court, we're looking for somebody who's safe to take care of that child. Family court has a whole different standard. There are 20 factors, and we'll get to those that we have to go down. And there it is, a responsible adult versus the best interest of the child. And I have to tell you the Perla v. Pope case, because it came out of our court in Sarasota County. This is an interesting case because for years I kept saying that when the dependency case ends, there's no jurisdiction then. You terminate jurisdiction. So how is this order going to be enforced in the family court case? And there it came from Sarasota County that it was not enforceable in the family law case. So you can have that order, you can file it in the family law case under seal, but the statute that provides for that does not provide for enforcement of it. And so Mr. Zamperla took Ms. Pope's case up, and that's Hermes Zamperla. He was a human cannonball. That's for your humor. And that's how I remember him all the time. I never forget the name of that case because he and his brother were both human cannonballs. And they both missed the net at one time, too. But anyways, he took it up, he took it up to the second DCA, and that's what the second DCA said, it's not enforceable. So I think there was a dispute going on about whether or not the mother could still have some visitation with the kids and how it was going to be supervised. And she took him back to court, and he took it up on appeal. He didn't like the judge's ruling, and he won. It was not enforceable. And then we're going to go over Florida Rule of Judicial Administration 2.545D, and that's the one that defines related cases. And it says it involves any of the same party's children or issues, and it's pending at the same time the party files a family case. But think about it. When you have a family law case and you have a dependency case, it involves some of the same parties, but the department is not a party to the family law case. But this is the rule that we operate under. I think you skipped too fast on that last one. Yeah, could you go back? Thanks. The second thing is it affects the court's jurisdiction to proceed. We already know the court has jurisdiction to proceed on both cases. And C, an order in the related case may conflict with the order. This is the big thing. We don't want conflicting orders. We don't want an order in the family law case that says that mom gets visitation 50% of the time unsupervised when she just had the kids taken away from her in dependency court. That's why we want this all under the unified family court system. And that's why we want to make sure that it's directed into that court. I don't know how often, I don't think there's any studies or statistics that will show how often the dependency court order is actually filed in the related case, because a related case may have existed before the dependency arose, the parties may be divorced, and then somebody's got to redirect that case into the dependency court. So I don't know how other jurisdictions do it, but I think that would be an interesting thing to find out. How often does that happen? I think that's an area that we can improve in our practice by having that order filed in the family law case, at least under a confidentiality seal, because otherwise the family law case may not, the family law judge may not know that there's a dependency case. And after the dependency case ends, if one parent is left with custody of the child, they really need to proceed in the family law case or have it decided by the dependency judge as to how that's going to be modified, because that dependency court order is not truly going to be enforceable in that family law case.
So what's a family law case?
This I find interesting, too. This is Florida Rule of Judicial Administration 2.545, because it names all the different types of family law cases, and dissolution of marriage, annulment, some support unconnected with dissolution of marriage. It names various cases that can be a family law case. And lo and behold, it names juvenile dependency cases, termination of parental rights, and juvenile delinquency cases as family cases. I just found that interesting.
So if that's a family law case, it's now subject to these principles, any of those things can be brought in. And that.
And this we already went over, so we can skip that.
We've been over this under the different models, and usually it's the one judge consideration. That's probably the most common version of it, although some places have panels. Oh, sorry.
Thanks. Okay, so now we're under Florida Statute 61.13, and this is all of the criteria that the family court must look at. It happens to be under the divorce statute, but the paternity statute also refers you there instead of going through all these again, these criteria. And this is what the court must look at in establishing or modifying parental responsibility and creating a parenting plan. You get the next one. And I'm not going to read them all, but they're going to look at which parent is most likely to communicate with the other parent, let them know what's going on with the child. Who's going to agree with the schedule and follow the schedule and not withhold the child? Who's going to provide most of the parental responsibilities, or are they going to delegate it to other individuals? I'm going to skip through these because I know them off the top of my head. The length of time the child's lived in a stable environment. Who provides the best routine for the children? Who's available to take care of the children? Maybe one parent's working long hours and leaving the child in the care of someone else, or maybe one parent isn't even exercising their time sharing and leaving the child with the grandmother. They're going to look at all that. The moral fitness of the parents. Well, you know, most of the time in a divorce case or something, we think, oh, that person's so immoral or something. But most of the time that does not come into play unless they've done something really horrible. They're going to look at the mental and physical health of the parents. They're going to look at the home, school, community record. They're going to look at whether a parent has a substance abuse problem, whether they're exposing the child to substance abuse, domestic violence, whether a parent has filed false reports with the court about domestic violence in the home or about child abuse. They're going to look at all of that. They are going to look at the reasonable preferences of the child. And one of the things that you need to realize, that is one of 20 factors. It disturbs me in the dependency court when we totally allow a child to make the decision of whether they're going to have a relationship with a parent again. That is not appropriate. We all have a duty and obligation to encourage that child to have a relationship with both parents unless something really horrible has happened. That child needs both parents. And even if a parent has made a mistake, used excess corporal punishment or something, we still must encourage that child to have that relationship. But for some reason, people that are involved in the dependency court often look at it that the child doesn't want to have a relationship with that parent anymore, and we have to protect the child. Think about it, because when the case is over, where's that child going to be? Okay? So that's only one of 20 factors in the family court case. Let's see, the next one is about how informed the parent is about the child's, needs, school record. Do they know who the teacher is? Do they know what kind of food the child likes? Do they know about the child's medical conditions? And the, ability of the parents to communicate. I already hit that one on evidence of domestic violence. And that's about evidence of filing a false report with the court. And they'll look at, did one parent typically perform most of the parenting? But honestly, in this day and age, if you've got two good parents, even if one parent did most of the parenting at home and they're getting divorced, oftentimes we wind up with 50-50 parenting plans. And you can read the rest of those. They're all pretty standard. There's 20 of them. And the last one that's kind of a catch-all is anything else that the court needs to know about. that might influence the time-sharing schedule. So the court's supposed to have a lot of evidence. 61.13, subsection 3, I think it is. Okay. So it's a very, very different standard of proof in family court. It's a lot more evidence than just the safety of the child. And basically, let me tell you, a child almost never gets to testify in regular family court. Never. I have filed motions to have a child testify at the time of trial, and pretty much what I've been told by judges is I'm going to deny that motion, or if the other party filed the motion, without prejudice. At the time of the trial, if you can't get your evidence in any other way, I'll make the decision then to have the child transported to the courthouse. Okay, and it's almost never allowed, and most judges have told me if the child isn't 14 or over, I'm not even going to consider it. Okay, so we try to not involve children in those decisions, and they shouldn't be involved in those decisions in dependency court either if parents are working their case plan and trying to be reunified. They should be involved in family therapy, especially with older children. The longer you wait to have family therapy with older kids in dependency court, the worse it gets. Okay, now we're going to talk about parenting plans, and we probably should move through those pretty quickly.
Okay, about parenting plans. This is the big deal for Florida. Does not use the word custody in family court, as you may know. Custody is the C word in family court, even though it's still used in dependency court. I know Ms. Salisbury and I both have, and I'm sure a lot of lawyers have, advised parents, look, get out of dependency court, bring this up in family court so you get a parenting plan. You're going to get a better deal out of those guys than you ever are in here, because you've got all these considerations that we've already gone over, and the people who are saying that you're a jerk the whole time, and I'm using jerk as a gender neutral term, you're a jerk, they're never going to change their mind about you because you blew it once and we can't trust you again. So we're going to say supervised visits, and that's that. Go to family court and get a parenting plan. There are a lot of different kinds of parenting plans. Most of them for regular people have contact schedules, who gets to enroll them in school, what holiday visits do you get to do international travel, what are the terms of those travel, blah, blah, blah. It just goes on and on. What we are trying to get to you today is that there is a way to get to a parenting plan in a family court setting with a domestic relation number, not a dependency court number, that's going to exist and be enforceable after juvenile court jurisdiction has ended. So what would that look like? Well, here, you want to talk about safe special needs? All right.
If you'll hit those things. Okay, so we were trying to look at special needs children because so often in family court, judges want to have the parents just work together, straight up shared parental responsibility, basically 50-50 time sharing schedule, and that's not always going to work with a special needs kid. And we're looking at kids that may have physical issues. We also want to look at their safety issues, concerns about one parent not being safe enough with the child, parenting skills. We want to look at many, many different things on what would be best for this child. In a regular marriage, and people that are getting along, parents don't usually do everything 50-50. Let's get real. One parent takes the child to the doctor, right, and handles the medical issues. One parent may meet with the teacher. One parent may do drop-off and pick-up. But once they're getting divorced or they're not going to be together, we expect them to agree on everything and share everything 50-50. It's just not realistic. And when you have a kid with special needs, that's going to be a different problem. So we're going to look at their safety issues, the parenting skills, who has the temperament maybe to deal with a child who has severe behavioral issues better, and we're going to look at their medical needs. Maybe mom happens to be a nurse or has some nursing background, and she's better off at making some of those decisions. So although it's a great idea to have shared parental responsibility, we also need to think about giving one parent ultimate decision-making authority, or we're going to leave that kid in a bad position. Other things we'll look at is, did anybody ever make any of the special arrangements? Did anybody take the child to OT/PT? Who's the parent that did that? You know, is dad the one that was working outside of the home most of the time? Is he going to be taking off of his high-paying job now to go take the child to these things? We need to really focus on the child more, especially when they have parenting, they have special needs. And here I've just listed for you some of the special needs that you might see. I think ADHD is a big problem because often we have a parent who says the child needs to be on the medication, and we have another parent that says, I don't want him on the medication. Well, if you leave them both with shared parental responsibility in that situation, and you don't give one parent the ultimate decision-making authority, where is this going? Then one parent writes to the doctor, you're not allowed to prescribe that medication for my child. Then the doctor kicks the child out of the practice because they don't want to deal with it. So it's a big problem. I think that the courts really need to carefully look at these issues and craft parenting plans that maybe say that the child will be evaluated by a psychologist who specializes in ADHD evaluations and not just brought to the pediatrician and said, we want medication for this. And that periodically this will be reviewed. And that if they can't agree that one parent has the ultimate decision-making authority, because otherwise that child may not wind up being treated. There's mental health issues, there's learning disabilities, who's been involved with the school, who's the one that helped get the special plan at the school for the child. Many, many things. I didn't list all the special needs.
You listed a few.
Yeah. I think ADHD is a huge issue, though, with the medications. And here's some of the modalities that they need to look at, whether there's an appropriate assessment. I can tell you, I recently tried a case where the mother had a lot of mental health issues. She took the child to the pediatrician and said that he needs medication for ADHD, and the pediatrician gave it to her. And he did not need ADHD medication. When he got placed with the father, he was taken off of that medication, and he's doing wonderfully. And he feels better. The child said he states that he feels better. So those are some of the issues we need to look at. And now we're going to show you a safety-focused parenting plan, just to show you what it looks like. This is a Supreme Court of Florida plan. It's on the website. It's available to anybody. It has to be filled out, and we'll go through some of the pages. The first page says whether they've agreed to this parenting plan, whether it's a proposed parenting plan to have the court entered, or whether it's one decided by the court. It goes on to say whether it's a final one or a temporary one. Next page.
Just so you know, this one we're showing you right now is on the Supreme Court website for anybody. You can download it in PDF format or Word format for modification. We are suggesting to you that in most cases, this will not work. Because if it would work, we already would be seeing these. Some effort was made a while back to get these done in dependency cases, and nobody wanted to take the time to fill them out. They're kind of long. We're just going to show it to you because we felt that some people may not have ever seen one, which is why this is up here.
Some of it's boilerplate language, some of it you have to fill in. I use them all the time in my family law practice, but I delete everything I'm not going to use because they go on for pages and they confuse people. And then, you know, somebody may say, well, why didn't we have that box? Why didn't we have this box? So whatever I'm not going to use or not agreed to, that was not agreed to, I delete it.
I know I'm going too fast. I'm sorry about that. But we're running out of time. We've got more stuff to show you.
And I think when Mike said that these aren't always going to work, the reason why it's not going to work is this slide. If it ain't easy, no one's going to use it. So we started looking at the safety-focused parenting plan and how could we pare it down. We have not done this yet, but this is what we're suggesting. We want to keep it simple, so we want to pare it down. We want to take a lot of information out of it.
So this slide is kind of an example. If somebody decides to do this in your circuit, Lord knows you're going to have meetings on it. Staffings, roundtables, brown bag this, after work that, whatever you got going on. Because we try to overthink everything we do. Some people in my community-based care agency can't go to the restroom unless there's a staffing. So it doesn't have to be like that. This is kind of a warning. Don't overthink it. Keep it simple because It only needs the information that's necessary to survive the extinction of the juvenile court jurisdiction. That's it. So we talked to a circuit court judge about this, and this is another example. If you look at this bag and you say, somebody hand me a chihuahua, all of those answers are correct, but they don't look alike. How they do it in Pasco County or Pinellas County or Manatee County or Leon County or you name it county doesn't matter if it looks different. No two juvenile court judges or courts in the same circuit do things exactly the same. As long as it works, as long as it's legal, as long as it meets the needs of the children and the family, it's as good as gold. So whatever you come up with is fine. And anyway, back to my judge story. We talked to him about this, and he said, look, if it's not simple, judges won't use it. So this is the same model that you just saw with about half the stuff pulled out. Jurisdiction is in the United States of America. We kind of know that, don't we? The UCCJEA has already been filed and it's legally presumed. We don't have to say that, do we, every single time? Now this is, in my opinion, still too long. But again, it's about half. And it does say some things, who can go to the school, who can go to the child's dance, who can go to the football game, so on. All right, this is my bit. Know what? Not everyone's going to like this idea. And if you don't like it, fine. Keep doing what you've been doing because everything works great in Dependency Court, doesn't it? Aren't we all happy about how great everything is? Okay, so I had a dream one time. My youngest daughter's in college. She comes to me while she's still in high school and she says, I've decided I want to go into biotechnology. Well, that sounds impressive. I didn't know she was a science girl, but that's what she said. And she won a science award when she graduated, so I was happy. She never talks about anything. How's school? Fine. Anything test? Nah, I don't want to talk about it. Off she goes. So she got into this gene splicing part of her biology class, and they talked to her about CRISPR. Does anybody know what CRISPR is? There we go. All right, CRISPR is a discovery that a bunch of people had. It was actually a little group of people, scientists, biochemist was part of the discovery group, and they came up with this methodology for gene splicing. The potential is off the chart. They can take a hereditary disease, they can, and the example they use most of all is sickle cell anemia. It's hereditary. The children of those parents are going to have sickle cell anemia. But using CRISPR, they can go in, take out the bad genes, replace it with a different gene, and that child is cured. Not only is that child cured, but that child's child is cured, and the grandchildren are cured, and the great-grandchildren are cured. The biological defect ends with this treatment. It's like a miracle. But it doesn't stop there. It can go into all kinds of areas, and in this book that this one discoverer wrote, designer babies came up. Will rich parents come in and say, well, I'd like my child to have blonde hair and blue eyes and be 6'2" and athletic and genius IQ. Is any of that possible? Well, all of that is possible. But is it ethical? And at what point do we stop being doctors and saviors and step into the role of gods? If you want to go that far with it. So that was the determination that she made. And the lady who helped invent this she said, I have this reoccurring nightmare. I go into this room and there's a man sitting in a chair. It's a completely blank room. There's one chair and the spotlight's on the man. And he turns around and looks at me, and it's Adolf Hitler. And he says, so, tell me about CRISPR. And she wakes up. So she doesn't want it to become a master race. So my daughter tells me she wants to do this. I buy the book. I learned this stuff I just told you. Now you know it. And so I had a dream. And in my dream, I come home from work, and my daughter, one more thing. If you are terribly interested in this, you can buy a fully functional CRISPR lab for your home for the low, low price of $2,000. And you can start gene splicing different things. This was in the book. So I know it's possible that she could be doing this if she felt like it. Fortunately, she wanted a nice computer. But one day I expect her to ask. And in my dream, she has asked, and she had her lab. And I come home, and she said, Dad, I've been working with CRISPR, and I got this great effect. It's in the kitchen. Come see. So I go in. And there is this. Look what I did to Coco. Isn't it great? Now, the dream gets a little fuzzy after that. I can't really tell you the details, but I will tell you this. At the end of the dream, she was delicious. All right. So, again, and we have more stuff, don't we? Is this the blank page? All right. So we've got a few minutes left. I want to tell you about something else. Debra and I went, and Mr. Chang over there, went to the American Bar Association biannual seminar. Every 2 years they put it on for lawyers representing parents. 2 years ago we went, and they were complaining about how things aren't going well. And they didn't have enough resources, and they weren't paid enough money, and blah, blah, blah. And over a 2-year period, they got their hands on some cash. And things had changed radically for them. Them being Washington State and New York. All the rest of us are wannabes. And they were kind of belligerent to us because we haven't done enough to change the way the child welfare system had been progressing. They called us co-spirators, or what was it they called us exactly? Don't remember. Anyway, we're being blamed. We're being blamed. It was very disturbing to me, and I wondered what they meant. And then they showed us this short film as an example of what they meant, and I found it today to be very much in line. Was that the next one? Oh, hang on. Well, let's see. We'll find it. With what the speaker said this morning. When we started looking at what's the larger purpose of the child welfare system, what are we doing? Has it worked? Where are we going? What should be different? This whole spiel I went to, oddly enough, the Guardian Ad Litem program in DeSoto County, Florida, and they were all over it. They said, this makes perfect sense. Why do we keep doing the same thing over and over, expecting a different results? And they wanted to look at a different approach altogether. And so I told them about this.
In the 70s, a research experiment found that when a rat is put in an empty cage, all alone with 2 water bottles, one normal and one drugged, it gets addicted to the drugged water and eventually dies of malnutrition. The experiment was seen as proof that drugs are uncontrollable, and it laid the foundation for 40 years of drug policy, with strict laws, rehab centers that focused on withdrawal, and a massive war on drugs, making it clear that drugs are bad. What most people don't know is that in the same decade, another scientist, Professor Bruce Alexander, thought it was obvious that lonely rats in boring cages would choose drugs over water. So he put them in a rat park, a lush cage with friends and everything a rat could want, while still having free access to drugs. Surprisingly, his rats chose not to use the drugs. The researcher even took the study one step further and had the rats use drugs for 57 days in the lonely cage until they became heavily addicted, and then placed them in the rat park. Astonishingly, the rats gradually reduced their drug use until they stopped using them altogether and lived the rest of their lives drug-free. Experiments like these happen to humans all the time. One example is in hospitals, where heavily injured patients are given a medical form of heroin. This heroin is much stronger than the heroin used by street addicts. Despite months of use, these medical users just stop when they go home to a life where they are surrounded by a loving family. The same drug, used for the same length of time, turns street users who were alone and unhappy into desperate addicts. The rat park experiments didn't show that chemical addictions don't exist, but it showed that they are not the only thing that matters in drug abuse. Maybe a person's access to a functioning social life and a lush cage are even more important than continuing the war on drugs mission of making drugs unavailable and penalizing the users.
Okay. So what that tells us is the war on drugs has led us fundamentally nowhere. We're running on a treadmill. We keep fighting the same problem the same way, and we keep ending up with the same people sometimes, or new people with the same problems. The speaker this morning said pretty much the same thing. People have to have adequate housing, people have to have a purpose, they have to have what they need to survive, and if they don't, they escape. And they escape, in this instance, through narcotics. So when you start talking about how we fix things, today we send people to programs. We send them to drug programs, we send them to anger management programs, we send them to therapists, and sometimes that works out, and sometimes it does not. If you start talking about the success rate, and success rates for me and her and others in this room is reunification, mostly. There are some people who will never be reunified. I've represented a lot of people over the years, and I can tell you some of them never need to be around children, including their own. But that's a very small number. Most of them can be fixed. A large portion of them are never fixed. And if you look back as to what's going on, we keep doing the same things. We send them to the same programs, we get the same reports, counselors change, but we're all on that wheel. We're on that treadmill. We run and we run and we run, and we basically barely move at all. This suggests a different approach, an approach that would be terribly expensive and would take a massive effort from governments, local and federal, state, local, and federal, to provide a housing facility so that people have a roof over their head, a decent roof over their head, in a safe neighborhood, transportation to a place where they could work, to give them value, to let them earn their own way, to let them learn a better way, and hopefully they'll move on, and some of them will and some of them won't. This can't be downtown anywhere. There are houses in Sarasota, Florida that are selling for over $1 million that look like they need to be torn down. But they're downtown Sarasota. And somebody one day is going to pay that $1 million to get that property. They'll tear that house down and so on. And everybody knows this. So finding a place for them to live, getting them public transportation to get in and out of their workplace, massive effort. I'm not suggesting how we do this, but I'm saying to you the conversation needs to go in that direction. And as you go back to your places, this whole video you just saw is on YouTube. It's got the unfortunate name of Rat Park. But if you go to YouTube and type Rat Park, you're going to see it. Just by contrast, the lady this morning with her PhD did a very wonderful presentation, very scientific, very beautiful. On the other end of the scale, you get a cartoon strip being drawn for you and colored, but the message is the same. So take whatever message you will out of any of that and use it as you will. Thank you very much for coming today. If there are any questions, you can come talk to us. Thank you.